All right, for today's question is, should I prototype or file a patent first? Hi, everybody. I'm JD Houvener, owner, founder, and patent attorney at Bold Patents Law Firm. Happy to be with you here today. I've helped inventors now for over 10 years, achieving nearly 500 patents as of today. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. That book and more is at the link below, the Bold Inventors Kit. So grab that today and get started on your adventure. So this question is great about how do you move forward? What's the first step? Do you prototype it and build it, even hiring someone, or do you file first and then go take care of that? The question, of course, depends. It's a legal answer. I would say it's case by case. If the invention is something that you, the inventor, need to be able to build to convince yourself that it works, then you should go build it. That might mean you need to go bring in another party, a third-party inventor, co-inventor, or engineer to just build a relatively crude but working example. I think it's enough for you to be able to make it so that it works, so that you can, yep, that is going to do what I think it does. Now, what this means is if you're inventing something outside your industry, where you're not really sure how something works, it's going to involve new technology, at least state-of-the-art technology that you're not familiar with. You want to be able to see it working and know that it's going to perform the utility, the benefit, the function that you think it does. Whereas if you've been in the industry for 10, 20 years, and putting A, B, and C, and now you're going to put D in there, the combination is going to be powerful. And you've seen how these elements work. You don't need to be convinced. You just know this will work. I'd say file first. Describe it fully. Of course, make sure you have it fully decked out in much detail as possible on your provisional, and then you'll build it, confirm, even test it by selling it in the market, and then come back and complete your non-provisional with all the details involved. So that's kind of the catch. If you need to prove it to yourself and make sure that it actually works, I would say prototype first. But if you know it's going to work and it's just a matter of time or a matter of money to get it built, but you've got the experience and know-how that, yeah, this will work, I'm confident, then file first. The benefit by filing first is you're going to be able to get the first early filing date. And that's what it is. The current law, as it is in the US, is it awards the invention, the patent, to who files first, not who invents it first. So there is some urgency here. Don't take months or even a year plus to prototype your invention. That could mean someone else, independently from you, could invent it, file it, and they get the rights, even though you conceived of it first. So don't be last. Don't be caught on your laurels waiting for the right time to file. Get a hold of us at Bold Patents. Our attorneys will be happy to help you research and file your invention as fast as possible. All right, everybody. Hope you learned a little bit today versus prototyping and whether you file first. I'm JD Houvener, patent attorney with Bold Patents Law Firm. Have an awesome day, everybody. Go big, go bold.